A century and a half ago, we fought a civil war and amended the Constitution to ensure that every human being could enjoy equal protection of the laws. But today, some states have denied that protection to children in the womb through legalized abortion. From the moment of fertilization, those victims of abortion are fully human. And in our legal tradition, every living human being is a human person. The Constitution says that no state can deprive any person the equal protection of the laws. And that is why legalized abortion is unconstitutional. In 2022, in Dobbs versus Jackson Women's Health Organization, the Supreme Court overturned Roe v. Wade, the 1973 decision that required states to allow abortion. Dobbs held that the Constitution does not confer a right to abortion through the 14th Amendment. But as significant as Dobbs was, it corrected only one of Roe's legal errors. You see, in order to wrongly say that the Constitution guaranteed a right to abortion, the Roe court first said that preborn children are not persons entitled to equal protection. If personhood is established, Justice Blackmun wrote in Roe, then the case for abortion collapses, for the fetus's right to life would then be guaranteed specifically by the 14th Amendment. Now, the justices in Dobbs were not asked to address the issue of preborn personhood, and the court didn't have to answer that question to decide the case. But we must ask, are preborn children persons within the original public meaning of the 14th Amendment? Is abortion unconstitutional? The 14th Amendment was ratified in 1868 after the Civil War to ensure that no human being would be denied basic legal rights. The amendment says states may not deprive any person of life, liberty, or property without due process of law, nor deny any person the equal protection of the laws. To understand the amendment's application to preborn children as persons, let's use three different interpretive tools. First, definitions from when the 14th Amendment was ratified. Second, historic state practices related to abortion. And third, the drafter's understanding of the amendment. First, definitions. According to dictionaries of common and legal usage at the time of the 14th Amendment's adoption, the term person was largely interchangeable with human being. So for example, the 1864 edition of Noah Webster's American Dictionary of the English Language defined the term person as relating especially to a living human being, a man, woman, or child, an individual of the human race. In legal usage, every human being was considered a natural person. The authoritative treatise writer William Blackstone actually began his discourse on the rights of persons with a discussion of the preborn child's rights to life and personal security. According to Blackstone, life is a right inherent by nature in every individual. For Blackstone, if human life existed, then legal personhood existed also. There was no distinction between biological human life and legal personhood. The 14th Amendment, similar to the Civil Rights Act of 1866 that it was meant to support, codified equal protection of the fundamental rights of persons, as these had been expounded by Blackstone and other treatise writers. Second, state practice. Centuries of common law practice consistently treated the preborn child as a person whenever it would be for his benefit. So based on authorities like Lord Coke and Blackstone, as well as landmark English cases, state high courts in the years before 1868 declared that the preborn human being throughout pregnancy is a person, and hence under civil and common law, to all intents and purposes, a child as much as if born. At common law, abortion was unlawful at all stages of pregnancy and was typically criminally indictable as soon as a woman was quick with child, a phrase that had shifting meanings. Some courts understood this to be as soon as the child was alive, or quick. Other courts understood this to be as soon as the child's life could be detected, sometimes called quickening. But this rule was designed to protect life as soon as it could be shown to exist, not to exclude protection prior to that point. In any event, the quickening distinction was largely discarded in the statutory reforms leading up to the 14th Amendment's adoption, so that by 1866, Chief Justice Tenney of the Maine Supreme Court could accurately report that the quickening distinction has been abandoned by jurists in all countries where an enlightened jurisprudence exists in practice. When the 14th Amendment was adopted in 1868, the states widely recognized preborn children as persons at all stages of pregnancy. Nearly every state had codified criminal prohibitions against abortion by statute, and at least 28 jurisdictions labeled abortion an offense against the person. In 23 states and 6 territories, laws referred to the preborn individual as an infant or child. In fact, the same Ohio legislature that ratified the 14th Amendment called abortion at any stage nothing less than child murder. So at the time of the 14th Amendment's adoption, nearly every state understood person to include prenatal life. Third, the framers' understanding of the amendment's legal application. The framers expected the 14th Amendment's guarantees of equal protection and due process to protect every member of the human species within U.S. jurisdiction. Senator Jacob Howard, who sponsored the amendment in the Senate, declared that the amendment's purpose was to disable a state from depriving not merely a citizen of the United States, but any person, whoever he may be, of life, liberty, and property without due process. Even the lowest and most despised of the human race were guaranteed equal protection. As Justice Hugo Black later put it, the history of the 14th Amendment proves that people were told that its purpose was to protect weak and helpless human beings. One mistaken approach to constitutional interpretation might claim that the 14th Amendment doesn't protect preborn children because it was most immediately intended to protect Black Americans from discriminatory, unequal treatment. But the amendment's framers deliberately chose the broader term persons to protect any human being who might be denied due process or equal protection. Another mistaken argument claims that the preborn can't be protected by the 14th Amendment because it begins by declaring that all persons born or naturalized in the United States are citizens of the United States. But the Citizenship Clause simply defines which persons are citizens, entitled to the privileges and immunities of citizenship. It doesn't define personhood or say that only citizens are persons. Indeed, it clearly acknowledges persons who are not citizens. And the Due Process and Equal Protection Clauses expressly protect any person, not just citizens. Finally, constitutional rights are typically only enforceable against the government, not against private actors. And this is called the state action doctrine. So a state's failure to protect an individual against private violence isn't usually a constitutional violation. So how could abortion be unconstitutional? Well, the Supreme Court has long recognized that the state may not, of course, selectively deny its protective services to certain disfavored minorities without violating the Equal Protection Clause. State laws that allow elective abortion deprive a disfavored class of human beings of the equal protection of the laws. Legalized abortion discriminates against preborn children because it means our general laws against homicide don't apply when the victim is an unborn child. And those are precisely the sort of wrongs that the 14th Amendment was designed to resolve. Equal protection for the preborn is not a new idea either. It's been around since before Roe itself. Even President Reagan agreed that the 14th Amendment applies to the preborn. He actually issued a proclamation in 1988 in which he said the well-being and future of our country demand that protection of the innocents must be guaranteed, and that the personhood of the unborn be declared and defended throughout the land. Every level and branch of government has a role to play in ensuring equal protection. Each state retains its primary duty to protect the inalienable right to life. But there's an important and inescapable federal role as well. First, the 14th Amendment specifically grants Congress power to enforce by appropriate legislation the amendment's guarantees. The Supreme Court explained in 1880 that whatever legislation is adapted to carry out the equal protection of the laws against state denial or invasion is brought within the domain of congressional power. Second, a pro-life president who understands the Constitution's protections for life can instruct each department and agency within the executive branch to recognize and protect human persons in the womb. And finally, courts should apply the original meaning of the Equal Protection Clause to extend those protections to unborn children. Preborn children are constitutionally entitled to due process and the equal protection of the laws. The Constitution, properly interpreted, prohibits abortion through the 14th Amendment, and everyone who swears an oath to uphold the Constitution has a duty to ensure those rights are protected. In America, abortion is unconstitutional.